Hi, everyone. Welcome back to In Her Wallet, a weekly podcast helping women around the world take control of their finances for good and build better financial futures one episode at a time. My name is Sofiia. I'm the host and the founder of In Her Wallet, as well as an accredited investment representative here in Canada. What we're talking about today is job loss, something none of us really wish to go through, yet a topic we must know how to navigate in case we do come across a situation like that. And in 2023, this topic is especially timely since the economy is slowing down and a lot of companies are downsizing and tightening their belts. Whether you're listening as someone who recently lost a job or are simply being proactive and want to educate yourself, our goal today is that after listening to this episode, you leave knowing how the employment law protects you in case of a layoff or a dismissal without or with cause, the things you are entitled to, as well as finances that company can pay you and how you can negotiate it so you leave nothing on the table and squeeze all the juices possible. And to help us answer all of these questions, I have an amazing guest, Erin Brandt, who is a lawyer and co-founder of PortaLaw, a Vancouver-based employment and human rights company that helps employees solve their problems at work. Welcome, Erin. We're so excited to have you on.
Thank you. Excited to be here.
It's a pleasure to have you as well. Erin, why don't we start with a little bit of an icebreaker so In Her Wallet community can get to know you better? Tell me in short form, what's your go-to coffee order?
I actually only recently started drinking coffee on a regular basis. I had my second kid, who is now a year old, and since him, my husband and I have become daily coffee drinkers. So at home, mostly just black coffee, and if I'm out, a latte.
Perfect. I'm a latte girl as well. And Erin, what's a movie you can rewatch again and again?
Um, I just told you that I've got two kids, like under the age of 4. So, I mean, who watches
No movies. Maybe like
those? I,
Disney movies.
I will say in my youth, I think I watched and rewatched Zoolander more times than I could count. So I know most of that movie by heart, and I probably
Yeah.
still would.
Okay. And I wonder if my next question will count because I'm going to ask you what's the travel destination you'd want to go to right now?
So actually, this weekend we're getting in the car and we're heading to Sun Peaks for some
Okay.
skiing. I'm hoping to put my older kid on skis for the second time. But otherwise, we're really looking forward to our next sun destination and beach and pool and
Yes.
sun.
I love this. Oh, you see, with this little icebreaker, we got to know that you have two children. You recently started drinking coffee. I love doing this. You to know a bit more about the person in such a short period of time. Okay, so let's dive into our conversation, Erin. To begin, can you tell us a bit more about PortaLaw, the company that you co-founded, and also what you do there?
Absolutely. We're employment lawyers, and so that means that we help people deal with problems at work. So for employees, we see a lot of people who've lost their jobs and are negotiating severance packages. We help them advise them on what they might be entitled to and help them negotiate for more. We help people who are dealing with human rights discrimination at work, bullying and harassment, things like, I got pregnant, lost my job, I have a disability, mental or physical, and I'm dealing with struggles with my employer, things like that, dealing with sexual harassment. And we also act for employers on the other side, helping them draft contracts, dealing with human rights accommodation, advising them on best practices, advising them on, what the law is with respect to employees and how best to create and foster healthy workplaces.
So, Erin, let's establish some common ground before we actually start talking in detail about losing a job. So, what's the difference between being fired, being let go, and getting laid off? And does employment law treat these three things differently? And are there any special terms to name this?
Yeah, so the terminology that I usually use is dismissal without cause, which is where employment is terminated permanently and it's not the employee's fault. Dismissal with cause, where employment is terminated because the employee did something really seriously wrong, and uh, temporary layoff. And so, comparing this to terminology that most non-lawyers would use, being let go would suggest a termination without cause. Getting laid off would be a temporary layoff, a temporary end of employment, a temporary break in employment, and being fired, most people associate with, I did something wrong and it was like this big dramatic thing. And so we
Mm-hmm.
really distinguish between, is it temporary, is it permanent, was it the employee's fault or not?
Got it. This is a very clear description. Thank you. Let's focus our first part of the conversation on layoffs. So you just mentioned that those are temporarily. I actually did not know that. Can you tell us other different types of layoffs?
Yeah, so under common law, which is law made by judges, companies don't have an inherent right to lay people off on a temporary basis unless an employee has consented to that either in a collective agreement or an employment contract or at the time of the layoff. So in 2020, and sorry, just back up a little bit. So at least in British Columbia, our Employment Standards Act says that employers are allowed to lay people off on a temporary basis, again, if the employee consents or it's outlined in the contract or a collective agreement for unionized workers. So short, where there's no consent, an employer doesn't really have this right to lay people off on a temporary basis. So in 2020, during those layoffs, it was, industry wide. It was across several industries. Layoffs were all over the place. And so the advice we were giving to employees at that time was, well, like, what choice do you have? Like, if you don't consent to this layoff, like, are you going to get a job at a different travel agency? And so at that time, most people, technically employers were breaching the law by laying off huge amounts of workers without their consent. But on the other hand, most workers were consenting because they didn't have another choice. Now, I actually am seeing layoffs happening again at work, and employers are sometimes forcing these layoffs on workers and saying, you don't have a choice, accept this or quit. And that's not quite true under the law. Employees do have a choice to either consent to the layoff or reject the layoff and treat their employment as having been permanently ended.
So if I consent, let's talk about if I consent, if I don't consent. If I consent to a layoff, what does that mean? Does that mean that the company promises that it'll bring me back after a certain period of time? And do they continue paying me partial salary or some salary while I'm being laid off?
So an employer wouldn't normally continue to pay an employee while they're laid off, but they would usually have a right to apply for employment insurance, EI, assuming they're otherwise eligible. But at least in BC, what it means is that an employer can lay an employee off with their consent for up to 13 weeks in any 20-week period. If the layoff lasts longer than that, the law will deem it to be a permanent termination of employment. And I do want to note that this law will change from province to province. That's how it works in BC. But in other provinces in Canada, the law might be different. And the advice that I can't give legal advice in this podcast, but the information that I'm giving today is really only relevant to the English speaking provinces in Canada. Quebec has a very different um, employment law framework. And so I'd recommend reaching out to someone who's qualified to give information about Quebec.
Thanks for making that distinction, Erin. And if I don't consent to a layoff, the company told me we're laying you off, but I say I don't agree with this. What happens then?
At least in BC, an employee would have a right to say, look, I don't consent to this. You've effectively ended my employment on a permanent basis. And an employee in that situation could ask for severance pay.
What is severance pay?
Okay, so we're moving into the next section. This is a nice segue, actually, into where I know you're going with this conversation. But
Yeah.
where an employee is let go on a permanent basis, and it wasn't their fault, they didn't do anything wrong. An employer would owe them advance notice, so working notice that their employment is ending, or pay in lieu of that working notice. So the courts, under the common law framework, the courts will look at the employee's age, the nature of what they do, the availability of other work, how long they were there for. So all these factors which go into, how employable is this worker and how likely are they to find work again? And the courts will come up with a framework to decide how much severance pay that worker is entitled to in lieu of the notice that they should have received. And so where a worker is laid off and they don't consent, it's effectively like a permanent termination situation. And so they can go after the severance pay that they should have received had they expressly been dismissed.
Hmm. So I want to back up a little bit and continue our conversation on layoffs. We will come back to severance pay because I do have a few questions about that in particular. But when we're talking about layoffs, besides, you did mention that the company continues to pay you. What else can you be entitled to if you consent to being laid off?
So normally an employer would not continue to would not continue to pay an employee during a layoff. The employee would have
Okay.
a right to file for EI during that time
EI with the government.
with the
Yes.
government.
We'll
Yeah,
talk about that in a bit. Okay. But do you continue to have your benefits?
that can really depend on the situation. I have seen some employers continue to provide extended health benefits during a layoff period, but I think it's also possible that an employer wouldn't.
So I assume it's something that can be negotiated, perhaps even.
Usually, look, layoffs are more common for seasonal workers in certain industries like logging or fishing. And so there are certain industry norms for those kinds of workers. Before 2020, I really didn't see layoffs. I really didn't see temporary layoffs outside of those seasonal industries. So this is all new stuff that we're dealing with. There's no real industry norm for, a regular company that usually employs employees on a permanent basis. There's no real standards for what companies are supposed to do in these situations.
Got
Um,
it.
the Employment Standards Act in BC at least doesn't say a whole lot about what an employer is supposed to do here.
Hmm. And one final question on layoffs. If I get laid off, let's say, is there a list of things I should immediately do that you, as an employment lawyer, would recommend?
So if an employee has received a letter that they're being asked to sign, they should read it carefully. They should figure out if the letter is actually lawful. The letter may include things that are or are not true under the law. An employee should make sure that they're not signing away any rights that they might have. Um, an employee can call the employment standards branch in the province where they live to find out more information about how the employment standards branch deals with temporary layoffs. Um, and an employee could also consult with an employment lawyer if they have questions that are really specific to their situation and are more complex than what's covered under the Employment Standards Act. So the Employment Standards Branch is a really great resource. They have helplines that are free to call, but I just want to caution that they're not lawyers. They can't give legal advice. They can't advise on contract law, and they can't advise on common law. So their area of knowledge is really limited to what's covered under the Employment Standards Act.
Got it. Thank you, Erin. That was very detailed. And I'll definitely try my best to include the link to that resource that you just mentioned for people who might be interested in that. So, moving on to being let go, we differentiated two types of being let go: with cause and without cause. Let's talk about the case where I didn't do anything wrong, but the company terminated my employment because, I don't know, for different reasons. Either they don't require a role like that anymore, or they don't have resources to compensate me. How does, and you did mention the way the employment law kind of protects me from that job loss is, first, I can apply for employment insurance, which should be done immediately after, and second, I might be eligible for severance pay. Correct me if I'm wrong or if I missed anything.
That's absolutely all correct.
Okay.
Um, so a worker who has lost their job may be entitled to either notice or severance. And it's an employer's choice whether they give the employee working notice or severance or a combination of the two.
Working notice, is that a financial payout as well?
Working notice is where an employer comes to you and says, in 4 weeks, your job is ending. We expect you to come to work every day. and we'll continue to pay you regularly. And at the end of the 4 weeks, you won't have a job here anymore.
Got it. And in that case, would employees still be entitled to severance pay after those 4 weeks or no?
They might not be.
hmm And in case I'm not given a working notice and they just say, starting tomorrow, you're not employed at this company anymore. In that case, does severance pay, is it guaranteed or not?
Yeah, so the law says that an employee is entitled to notice, but if the employee doesn't receive notice, then they're entitled to pay instead of that notice. So a lot of workers will come to me and say, I just lost my job. I didn't have any warning. I didn't know this was coming. They didn't give me any heads up that this was happening. And an employee is not entitled to notice if the employer gives them severance instead. So it's the employer's choice if they want to give the worker notice that their job is ending, or if the employer wants to give them pay instead of that notice.
hmm And Erin, my next question for you is, are there standards for how much severance pay is supposed to be?
So in the English speaking provinces in Canada, we'll look at the Employment Standards Act and we'll look at the common law. Um, so under the Employment Standards Act in BC, it's a framework of 0 to 8 weeks of notice or severance, and it depends on how long the employee has worked there for. So if the employee has been there for 3 months or less, an employee is not, there's no minimum requirement to give any notice or severance. If an employee has been there for 3 months or more, the minimum is 1 week. If the employee has been there for more than a year, it's 2 weeks, and it goes up from there.
Got it.
It's the minimum, though. That's kind of like minimum wage, where an employer has to pay you at least that amount, but that's not the maximum. So we
But I
also, oh,
do
sorry, go ahead.
Sorry, but I do know there is in fact a maximum because whether worked at the company for 5 years or 8 years or 20 years, I think there is some threshold at which the maximum has been reached and you're not entitled to more. Can you talk a bit about that?
Yeah, so after an employee has been employed for 8 years, they're entitled to 8 weeks under the Employment Standards Act, and that's the maximum minimum standard. So these are minimums. So after an employee's worked there for 8 years, they're entitled to 8 weeks, and this is different in every province. Every province has a different piece of legislation that deals with this, and these amounts of notice change from province to province. So if you're not in British Columbia, you should definitely consult the Employment Standards Act in your province. But that's not the whole story, and a lot of people think it is. The Employment Standards Act is like minimum wage. It just sets out minimum amounts. We also have to look at the common law. So the common law, like I said, is law that's made by judges over the years. And under the common law, we look at a framework of roughly 1 month of notice or severance per year of service, up to a maximum of 24 months. And so an employee who's 64 years old in a senior management position and has been there for 20 years is going to be entitled to a really significant amount of severance pay under the common law. An employee who's 18 years old, working at a coffee shop for a minimum wage and has been there only a few months is not going to be entitled to very much notice or severance. So every person's situation is different. It's very contextual under the common law.
So what I'm catching here is that severance pay that is governed by employment law has more or less very strict frames that you either fit in or you do not fit in. Versus common law, there is more room for to get more payout. However, that's something that needs to be negotiated with the company.
Exactly. And so if you're in a situation where you're a long-term employee, you're an older worker, you've got a really specialized skill set, it is usually worthwhile to speak with an employment lawyer. But these two frameworks are not the only, again, this is not the whole story. There's one more area that's important to look at, which is the employee's employment contract. And so it's not an employer can never write a contract which says that they get less than the minimum standards under the Employment Standards Act. Like an employer can never say, we're going to pay you less than minimum wage and you agree to that. That's not lawful. And similarly, an employer can never say, we can fire you at will at any moment for any reason and not pay you any severance. That's not legal in Canada. It's legal in the States and a lot of states, it's not legal here. Yeah, I mean, different states have different rules about this, but at will employment is a term that's used in the US really frequently, which means that the employer has the ability to just fire at will. And that concept does not exist under Canadian employment law. So an employee's contract may have something to say about how much notice or severance they're owed if they lose their job. And so we also have to look at the contract. And as long as the contract complies with the Employment Standards Act, it can it can displace the common law, meaning an employee may have agreed in an employment contract that they don't get 12, 15, 18, 24 months of severance. Their contract may say that they only get 0 to 8 weeks, consistent with the Employment Standards Act. So these are the kinds of things that we look at as employment lawyers, and the kinds of questions that we're asking in trying to figure out who is this worker? What kind of skill set do they have? What are their personal characteristics? And are they entitled to more severance than what they've been offered?
My first thought from what you've just said that kind of pops up in my head is how important it is to go through your contract when you are signing a contract for new employment, to pay attention to that part, perhaps, right?
Absolutely. It's usually written in technical legal language, and the average person isn't going to understand that they're actually signing away their rights to greater severance. And so, one of the other things I didn't mention we do is before employees sign a contract, we'll read it, explain it to the worker in plain English, and explain, and help them try and negotiate for a better deal. It's like getting divorced. Like most people aren't thinking like when they accept a new job, oh, I could get fired one day, right? Or what will happen if I lose my job?
Totally.
But it's like a prenup. It is important to understand what could happen if the employer decides to end the relationship, and what that will mean for you financially.
Great that you mentioned about prenup. We actually did an episode in season 1 on prenup. So for anyone listening, if you haven't checked that episode out, definitely go ahead. I absolutely love it. And it was with a family lawyer as well. So we have 2 lawyer guests already on our podcast and hopefully counting. Erin, so moving on, I'm looking here at my list of questions. What happens if you don't agree with what the company has offered you? Obviously, first thing, don't sign anything off right away. Take the
Don't sign
time.
it right away. Take it home. Talk to your partner. Talk to a family member that you trust. Um, do some Googling, check out the free resources on my website, portalaw.ca. We've got this section called Open Porta, which has a lot of the stuff I'm talking about today. And try and figure out if it's worth it to talk to an employment lawyer to see if you might be entitled to more. Um, if you think you are entitled to more, it's always possible to negotiate to try and ask for more. Often employers like sometimes employers will offer, at the lower end of what they think is reasonable, hoping the employee accepts it, but anticipating that they might not. So there often is room to sweeten the deal. Even if it seems to be a fair offer, there still might be room to sweeten it somehow.
Mm-hmm. And Erin, if we talk about now, if we move on to talking about dismissal with cause, so if you actually got fired for doing something really bad, what am I still entitled to anything in a situation like that? To severance pay, to work notice? Let's go over that quickly.
So, where an employee has done something really seriously wrong, an employee is not entitled to notice or severance pay. And I usually tell people that it's something that has to shock me. It has to be really, really bad, like theft, dishonesty, assault. Something where the employer says, wow, that was awful. It is not possible for us to continue to employ you here. Um, we don't trust you. You've other workers refusing to work with you. What you did was very, very horrible. Short of that, there's no cause. So it's black and white. There's no middle ground here. There's not like, well, we kind of have cause, you kind of did something wrong. Either there's cause or there isn't cause. And where there is cause, an employee is not entitled to notice or severance. And the
Let's
burden
say
is on the employer to prove that what the employee did was so wrong that they shouldn't get severance.
you did say that it's black and white, but I want to give you a scenario where that might be common, I think. I wonder what's your take on that. Let's say I have a sales job and I have certain KPIs to hit every quarter. And I've been successful when I just started, but let's say I'm having a tough time right now and I haven't hit my quarterly KPIs in, I don't know, several times right now. I've got warnings, but then all of a sudden I don't hit it again and the company fires me. Is that considered dismissal with cause?
So performance issues over time can be caused where an employer can prove that they've established a clear standard, where they've warned the employee that they're not meeting the standard, where they've given the employee an opportunity to improve, and really key is where they've warned the employee that a failure to improve could result in dismissal. So it's very common that I'll see those first three elements, and those first three elements are present in your situation that you've explained, right? That there's a clear KPI, the worker isn't meeting those KPIs, they're being warned that they're not meeting them, and they're being given a real chance to improve. But the employer has to also warn the worker that if they don't improve, they're facing dismissal for cause. And even then, it's really common, even in that situation where an employer might be able to prove just cause, um, it is still common that an employer will terminate the employment relationship without cause and provide severance.
So I assume that's when professionals like you come into play and help the employee navigate these waters and understand whether dismissal was for cause and what, and if the company can be held accountable for perhaps doing it the wrong way.
Exactly.
Got it. And Erin, if we look at dismissal with cause and without cause, what is your what are the things both of these people should immediately do when they lose employment? And if these
Don't,
things are different, maybe.
don't sign anything, take it home. You know, learning that you've lost your job can be a really traumatic event, right? It can be really, really difficult to think that you're doing well and be blindsided by loss of employment. That's a really difficult situation to be in. And when someone hands you a piece of paper and says, sign here, like you shouldn't be making decisions in that moment. You should take home the offer, sleep on it, think about it. It's very common that employers will offer you, that the offer will be open for a week to think about it. Take that week, think about it. If at the end of the week you decide that you want to sign the paperwork, fine, that's your personal choice. And that is a valid choice for many people. But if throughout that week you sit on it and you think, you know what, no, this isn't fair. I think that there's more that I can negotiate for here. Um, then you've given yourself the opportunity to make that choice.
Mm-hmm. Thank you, Erin. That's a very good description. I also want to say that getting your record of employment probably from your employer and then applying for EI, right? Right
Yes,
away.
yes.
When you start applying for EI, for employment insurance, which is, let's explain for those who might not know what employment insurance is, payments, subsidy payments, right, by the
It's
government.
a government program which is designed to help workers who have
Lost.
lost their jobs either temporary or on a permanent basis. So when there's an interruption in earnings, so an employee goes on a leave of some kind or loses their job, an employer has to file a record of employment with Service Canada, and they're supposed to do so within certain time limits. But an employee can apply for EI even before the record of employment is filed. And I actually recommend that workers do that because their entitlement to EI will be based on the date of the employee's application. So if the employer delays for some reason in filing the record of employment, it's still important to go ahead and file for EI right away. But a worker cannot get both severance and EI for the same period of time. EI payments will start after the severance period has ended. So if a worker gets the equivalent of 2 months of severance, then EI payments will start after 2 months.
Got it. Okay, that's good to distinguish. Erin, I think we've covered everything I was planning to go over today. My two final questions to you are the two questions I ask every guest. And the first one is, what does financial freedom mean to you?
That's a really good question. And I saw that this morning before we started chatting, and I was like, I don't have an answer to that question. And maybe I should. And maybe I should listen to your podcast so that I can figure that out. I think financial freedom means being able to choose what I do. having the luxury of being able to choose what kind of work I do, who my clients are, and choosing the work that brings me joy.
I love that. And only a few guests on the podcast have given that answer, and that's the answer I think I'd give if I were in your position to answer that. So that's, yeah, I totally agree with you. And what do you think in that case every woman who strives for financial freedom should do to get that freedom of choice?
Yeah, I mean, not it's hard. Like, we have to do what we need to do to put food on the table and to pay our bills and to get through the day, right? At the end of the day, like we have to do what we have to do. Work is hard. That's why it's called work. Um, but one of our key values at PortaLaw is joy. Um, that I believe that people should find joy at work, that managers and business owners should find joy at work, um, that at PortaLaw that we should find joy in the kinds of work that we're doing, the kinds of clients that we're working with. And we're starting to internalize this as our mission statement. And so when I'm trying to make a decision, I ask myself, would doing this thing bring me joy? And if the answer is yes, then it's easy. And if the answer is no, then I have to really reflect on, is this something I really want to do then? Like if this is going to make me angry or upset, or it's just not something that's going to make me happy, then it's something that I'm going to try and say no to.
I really like what you just said. And I think the book I'm currently reading called Essentialism, it reflects that philosophy. So if you haven't read it, I definitely recommend. I really like it so far. Erin, thank you so much for being with us today and for sharing your knowledge about employment law. I think this episode will be very well received, and I think a lot of people are in need of that. How can In Her Wallet community get in touch with you if they are would like to learn more or would like to get your services?
Yes, people can visit our website, portalaw.ca, portalaw.ca. We're on Facebook, we're on LinkedIn, we're on Instagram, or they can email me at Erin, Erin, at portalaw.ca.
Perfect. That was clean. Great. Thank you. In Her Wallet, I hope you guys enjoyed this episode. Please share it with your family and friends and whoever you think might find this information useful. Friendly reminder that season 2 of In Her Wallet podcast is also video recorded, so you can access and see me and Erin chat on our YouTube channel, In Her Wallet. Ladies, thank you all for tuning in today. As always, I want you to give yourself credit for showing up for yourself and your future, because every time you increase your financial knowledge, you increase what's financially possible for you. I'll see y'all next week. Bye.